The courtroom went silent the moment Judge Caprio took off his glasses and looked straight at the man in the navy suit. Not at the lawyer, not at the paperwork, at him. "Mr. Mercer," he said, his voice low enough that people leaned forward to hear it, "are you asking this court to believe that 8 widows, all over the age of 70, just happened to lose money the exact same way, into accounts you controlled, and you noticed none of it?" Daniel Mercer didn't answer right away. He swallowed. His cufflinks flashed under the courtroom lights. Outside, rain tapped against the old Providence windows, but inside, nobody moved. On the front bench, a woman in a charcoal coat gripped a folded photograph so tightly the edges had bent white. Behind her, reporters were already writing. That was the moment the defense died. Because up until then, Mercer had walked into court carrying himself like a man who had spent 22 years inside private banking, wealth management, estate planning, and the kind of quiet rooms where signatures move millions. He had the smile, the posture, the rehearsed injury of an innocent executive falsely accused. One misunderstanding, he claimed. Clerical confusion, authorized transfers, sloppy record-keeping by grieving families who did not understand trusts. But this was never one bad transfer. And that is what made the case so ugly. What started as a complaint from one widow, who thought her late husband's pension reserve had been mishandled, became an audit. That audit became a pattern. And that pattern led investigators into one of the coldest, most calculated little theft operations they had seen in years. Not a smash and grab, not a desperate embezzlement spiral, but a patient system built around people too heartbroken to detect it quickly and too intimidated to challenge a banker who spoke fluent authority. By the time the truth reached Caprio's courtroom, it wasn't about missing money alone. It was about how greed learns to wear a tie, speak softly, and hide behind fine print. And if you appreciate stories where power finally meets consequences, stay with me, because what happened next turned a polished defense into a public autopsy. The first widow was Eleanor Briggs, 74, from Cranston. Her husband Arthur had worked 36 years repairing boilers at a state facility. He died in February of 2023, and within 5 weeks Eleanor noticed something small and strange. 2 outgoing transfers she didn't recognize, each just under $10,000, labeled structured reallocation. She called the bank. Mercer called her back personally. That should have reassured her. It didn't. He spoke too quickly, told her the transfers were routine trust optimization, said her husband had signed broader discretion language in 2018. When she asked for the signed instruction, she got delay. When she asked again, she got a copy with a signature that looked right until it didn't. Same slope on the A, same hard pressure on the final S. But Arthur Briggs had arthritis in his final years. He printed more than he signed. Eleanor knew it immediately. So did her daughter. Then came widow number 2, Lorraine Velez, 68, East Providence. Then a third in Warwick. Then a fourth in Pawtucket. Different accounts, different estates, same internal language. Same transfer windows, same destination pathway through a shell advisory entity called Harbor Crest Fiduciary Solutions, a name that sounded institutional enough to avoid panic but led, eventually, to an office suite with 1 mailbox, no staff directory, and paperwork tied back to Mercer's brother-in-law. That was when the story stopped being ordinary. Investigators from the State Banking Compliance Unit pulled the account histories. At first, Mercer's defense team thought they had room to maneuver. The sums were fragmented, nothing theatrical. 7,000 here, 11,000 there, 12,800, 9,400. Small enough to avoid immediate alarms, large enough to matter. He had chosen his numbers the way some thieves choose gloves, not to stand out. But patterns do not care how elegant you think you are. Across 14 months, prosecutors traced 43 suspect transfers from 12 estate-linked accounts. 8 of those account holders were widows. 2 had early-stage dementia diagnoses documented in care records. 1, 81-year-old Margaret Linsky, had lost her husband and son within the same 6-month span. Mercer's notes in the internal client system described her as emotionally dependent and unlikely to challenge allocation strategy. Those words would come back to bury him. His lawyers tried the obvious route first: administrative complexity, delegated authority, back office misclassification. They argued Mercer was a relationship manager, not the final movement approver. They said he relied on internal operations staff. They said grief had distorted memory, that families often forgot what had been signed during end-of-life planning. Then prosecutors put up the timeline. March 3, 2023, 9:14 a.m., Mercer emails operations requesting expedited trust liquidity shifts on Briggs estate funds. March 3, 2023, 9:22 a.m., Mercer texts a subordinate, "Push today before daughter gets access." March 3, 2023, 4:41 p.m. Close to $9,800 leaves Eleanor Briggs' account, not theory, not interpretation, sequence. And Mercer still thought he could talk his way through it. Inside court, he sat with that wounded professional expression men like him practice in mirrors. He told the judge he had acted in good faith under complex fiduciary circumstances. He said any language in text had been taken out of context. He even implied some of the widows had verbally approved actions they later failed to remember. That line changed the air in the room, because one of those widows, Patricia Hall, age 79, was there that day. Her husband had been a marine mechanic. She walked with a cane, wore white gloves, and when the prosecutor asked whether she had ever verbally approved a transfer to Harbor Crest, she said, "I asked him if my husband's money was safe, and he said safer than in my own hands." You could feel the courtroom tighten around that sentence. If cases like this make you think, let me know in the comments, because that one line told you everything about the moral geometry here. He did not just take money, he exploited trust at its weakest point. Still, the center of the case, the point where Mercer's defense became impossible, was not the widow's testimony. It was the document he never expected anyone to find. A compliance analyst named Renee Coe had been reviewing dormant audit flags when she noticed that several transfer authorization PDFs carried identical metadata signatures, same creation software, same device ID, same editing timestamp pattern. That should have been impossible if the forms had been signed by different clients on different dates over several years. The forensic lab pulled the originals. What they found changed everything. 7 authorization forms had been assembled from older estate documents. Signatures had been lifted from archive beneficiary updates, digitally overlaid, then flattened into fresh-looking PDFs. On 3 forms, the footer still contained a hidden file path from Mercer's own workstation login. On one, the widow's supposed signature date fell 6 days after she had been admitted for emergency hip surgery and sedated in Kent Hospital. On another, the witness line bore the electronic initials of an assistant who had been on maternity leave in Florida that week. The problem was proof. Then investigators found it. At 11:38 p.m. on June 17th, Mercer had logged into the internal document portal from his home IP address and accessed 6 client signature cards in a 19-minute window. At 12:06 a.m., a printer on the bank's 6th floor, remote authorized under his credentials, generated revised trust instruction packets. At 8:11 a.m. the next morning, 3 outgoing transfers hit Harbor Crest. That wasn't negligence, that was architecture. And Judge Caprio knew exactly what he was looking at. He asked Mercer a question so simple it was lethal. If these clients truly authorized the transfers, why did you need their old signatures after midnight? Mercer looked to his lawyer. His lawyer looked at the table, no answer. Then Caprio went further. He started reading Mercer's own performance bonus records into the court file. In 2023, Mercer's compensation included incentive tiers tied to assets moved into fee-generating advisory channels. Harbor Crest, the shell entity, routed funds into short-duration instruments producing management fees that kicked back through consulting arrangements. Not enormous money by hedge fund standards, but enough. $32,000 here, $51,000 there. Over 18 months, prosecutors estimated Mercer personally benefited by just under $286,000. For him, it was a revenue stream. For those women, it was medication, property tax, funeral debt, groceries, heat. That contrast is what finished him. The defense made one last attempt. They argued no widow had been rendered homeless, that some funds had later been partially restored, that the bank itself had not collapsed, that Mercer had no prior criminal record, that his community service and church board work reflected character. Caprio's face did not change. He said, "Character is what a man does when the person across from him cannot fight back." Then he turned to the widows. One by one they spoke. Eleanor Briggs sold her husband's tools because she thought the estate had been overtaxed. Lorraine Velez delayed cataract surgery for 8 months. Margaret Linsky stopped sending money to a grandson in community college. Patricia Hall said the worst part was not the loss. It was being made to feel foolish for asking questions. And there it was, the real injury. The theft was financial. The damage was human. By the final third of the hearing, the institutions themselves were falling in line. The bank announced Mercer's termination for cause. State regulators moved to revoke his licenses permanently. A parallel civil action froze his brokerage accounts, his vacation property interest in Narragansett, and 2 college savings vehicles funded in his children's names days after subpoena notices went out. Prosecutors called that attempted shielding. His attorney called it family planning. The court called it what it looked like, asset dissipation. In plain English, moving money before judgment could reach it. That decision detonated the last shelter around him. The judge authorized expanded restitution, referral for criminal fraud charges, and findings supporting punitive exposure in civil court. Reporters would later describe it as the moment Caprio bankrupted the defense, not because he emptied Mercer's accounts with one sentence, but because he stripped away every respectable explanation the defense had tried to hide behind. Good faith was gone. Misunderstanding was gone. Clerical error was gone. What remained was greed, documented line by line. Mercer finally spoke near the end, quietly, no polish left. "I never meant for anyone to suffer. It might have worked somewhere else, maybe on television, maybe at a shareholder luncheon, not there." Caprio answered without raising his voice. "People like you always describe the damage in passive tense. Money vanished, trust eroded, suffering happened. But suffering did not happen here, Mr. Mercer. You caused it." And that was the ruling people remembered. Not because it was loud, because it was precise. Restitution orders followed. Civil penalties followed. Criminal proceedings continued beyond that room. The widows got part of their money back through emergency compensation and seized assets. Though anyone who has watched cases like this knows the cruel truth, repayment is not restoration. You can return dollars. You cannot return the months of fear, the second-guessing, the humiliation of being patronized by the man robbing you. If you believe no one is above accountability, subscribe. Because stories like this matter for a reason. They matter because crimes committed in silence are often mistaken for sophistication. Because a press suit still opens doors that should remain shut. Because the people most likely to be dismissed as confused are often the first to notice when something is wrong. And because institutions only deserve trust when they are willing to act against their own, not protect them. Long after the hearing ended, Eleanor Briggs stepped out into the wet Providence afternoon holding the same bent photograph she brought in. Her husband was in it, younger, smiling, grease on his hands from a life of work that had left something honest behind. She stood on the courthouse steps while cameras crowded below and said just one thing. He thought no one would listen. That may be the cleanest summary of the whole case. Daniel Mercer did not fall because he was careless. He fell because he believed grief makes people weak, age makes them ignorable, and authority makes him untouchable. He was wrong on every count. In the end, it was not outrage that destroyed him. It was patience, records, timestamps, a judge who knew the difference between a mistake and a method, and 8 widows who kept asking the one question men like him can never tolerate for long. Where did the money go? Once that question was answered, everything else followed. The suit, the silence, the excuses, the posture, all of it washed away, and that is the part people should remember. Not the banker's fall, but the illusion that protected him until the facts arrived. Because arrogance always sounds expensive right up until the bill comes due.